Member for Scarborough-Guildwood.
Thank you, Madam Speaker, for this opportunity. At the outset, I'd like to say I'm splitting my time with the member from Brampton Centre. Madam Speaker, this initiative actually goes back quite a long ways for me, and I want to recognize the former member from Kitchener Centre, the Honourable Karen Redmond, who raised in caucus and outside of caucus for us, and particularly for people like myself who are not from Kitchener, the issue of Ashley Smith and her death and how it affected so many of us. I want to just read, to begin with, the rather dry initiative with respect by the coroner's report, which says, coroner's inquest touching the death of Ashley Smith. Name of deceased Ashley Smith, date and time of death, October 19, 2007, 8:10 a.m. Place of death, St. Mary's General Hospital in Kitchener. Cause of death, ligature strangulation and positional asphyxia. By what means? Homicide. Age 19. Now, that is the dry and coroner's way of introducing what is, in fact, a substantive report and does form, in part, the basis for the initiative in C-83. The newspaper report is a little bit more graphic. Smith, 19, was originally from Moncton, New Brunswick, was imprisoned in the Grand Valley Institute in Kitchener, Ontario, where she died in 2007. She had tied a piece of cloth around her neck while guards stood outside her cell and watched. They had been ordered by senior staff not to enter her cell as long as she was breathing. Miss Smith had been moved 17 times. She had been incarcerated in 5 institutions in 5 different provinces. Clearly a troubled young lady, but still, Mr. Speaker, a massive failure on the part of the institutions that were responsible for housing her and ultimately for her death. The minister of the day, the honourable member from Bellechasse-Lévis, said after the receipt of the coroner's report, "My thoughts and prayers go out to Miss Smith's family. I've asked my officials to review carefully the jury's recommendations." That was December 19, 2013, and at that time he was the Federal Minister of Public Safety and Emergency Preparedness. So, Madam Speaker, so here we are, some 5 years later, more than 10 years later after Ms. Smith's death, and looking at the incorporation of many of the recommendations that were contained in the coroner's report. Clearly nothing was done from 2007 to 2015, when the previous government ceased to be the government, and we are now 3 years later into preparing this, and in some respects driven by the forces of civil society, but also by the reality of 2 lawsuits which essentially at its core mean that the current system is not a sustainable system. Among the recommendations of the coroner's report, that CSC ensure nursing services are available on site for all inmates, that CSC expand the scope and terms of psychiatric contracts to enable them to perform duties in a meaningful way, decisions about clinical management of inmates be made by doctors, not CSC staff. Inmates must have access to an independent patient advocate system. Indefinite solitary confinement for prisoners be abolished. meetings between prisoners and support staff should not happen through food slots, something that happened frequently with Smith. So, Madam Speaker, we have a long way to come, and I don't pretend to assume that Bill C-83, in fact, responds to each and every recommendation. And my colleague, the NDP critic for public safety, highlighted some of the real questions that are properly posed before, to the minister before a committee, and hopefully the responses of both the minister and the head of Corrections Canada will be helpful in assuaging him about the concerns that are legitimately raised both in the coroner's report but also in the lawsuits that have come up. The Prime Minister himself was so concerned about the inadequacies of, for want of a better term, solitary confinement, that he actually incorporated it into the mandates of the Justice Minister and the Public Safety Minister. The Justice Minister mandate says, recommendations from the inquest into the death of Ashley Smith regarding the restrictions of the use of solitary confinement and the treatment of those with mental illness. That's right in the mandate letter of the Minister of Justice. In the mandate letter of the Public Safety Minister, we get, quote, address gaps in services to Indigenous people and those with mental illness through the criminal justice system. So, Madam Speaker, in 2007, we have a 2013, we have a coroner's inquiry and recommendations coming out of the death of Ashley Smith in 2007. In 2013, the Conservative Party says our thoughts and prayers are with you. Government becomes the government, the Liberal government becomes the Liberal government in 2015. Incorporated into the mandate letters of two senior ministers are the requirement that they deal with these issues, and here we have now C-83 on those issues, Mr. Speaker. In addition, the Corrections Commissioner has further been mandated to help create a, quote, safe, secure, and humane corrections environment and to address the physical and mental health of inmates, among other priorities. In fact, 2 weeks ago, Madam Speaker, we had the new head of CCS, Ann Kelly, to speak to her mandate. Indeed, members had every opportunity to question her about her mandate and also to see how this particular part of her mandate might well be fulfilled. Perhaps most significantly, Madam Speaker, Bill C-83 will put an end to segregation. In Ontario and British Columbia, two constitutional challenges have found that the legislation governing the administrative segregation is contrary to the Charter of Rights and Freedoms. And my friends in the Conservative Party might wish that to go away. They probably wish that the Charter would go away. But nevertheless, the two of the most significant provinces in the country have said that the way things are being done is not sustainable and is contrary to the Constitution. And it is quite clear that what is motivating, in part, beyond the mandates, etc., is the reality of the NGO community and these class action lawsuits. So the time is clearly to act is now. It is clear that large parts of the administrative segregation provisions of the Correctional and Conditional Release Act will no longer be in existence in two of Canada's most populous provinces. The Conservative Party's position seems to be just let people sit in the current system anyways. That is not either a morally or legally sustainable position. So, Madam Speaker, putting the prisoners into taking them out of an administrative segregation and putting them into a situation is actually, in my judgment, a greater benefit to public safety. So I see, Madam Speaker, that my time is up. I thank you for your attention. I look forward to questions from colleagues.
Questions and comments? Questions et commentaires? The honourable member for Niagara Falls. Niagara Centre.
Thank you, Madam Speaker. Madam Speaker, Bill C-83 eliminates administrative segregation. Instead, people who have to be separated from the mainstream inmate population, generally for safety reasons, will be assigned to a secure intervention unit. The acronym is SIU. Madam Speaker, my question to the Speaker, or to the presenter is what would be the difference between the new secure intervention unit and administrative segregation?
The honourable member for Scarborough-Guildwood.
Well, thank you, Madam Speaker. There's clearly an effort to make the secure intervention unit an environment that allows those who are very troubled prisoners to have more human interaction. There's actually a mandated time that they will be allowed to interact with other human beings, that there's a mandated time that they have to interact with healthcare professionals, that there's a mandated time in which there is a review of their paths to progress. At the end of the day, Madam Speaker, almost everybody gets back on the street. Almost everybody. And so we can, wish that they come back onto the street whole. That's just wishful fantasies, Madam Speaker. So the prison system needs to be mandated to make people as able as possible to reintegrate into our society to maximize public safety.
Questions and comments? The honourable member for Caribou-Prince George.
Thank you, Madam Speaker. And I want to ask our honourable colleague through you how the desired outcomes of this bill will be measured, and B, can they tell Canadians today how much the implementation of this bill will cost? Thank you.
Honourable member for Scarborough-Guildwood.
Madam Speaker, the measurement of the success of this bill will be over time, absolutely necessarily, because you have currently a system that is not working, that's constitutionally deficient, that offends the Charter of Rights and Freedoms, that has a little too many Ashley Smiths, if you will, in the system. So the improvement will be hopefully measurable over time, and I'm sure that the head of CCS will, in fact, have some metrics to share with the committee. With respect to funding, Mr. Speaker, we are certainly in recovery mode from the previous government. The hundreds of millions of dollars that have been cut out of the system are clearly having an impact, and that is extremely regrettable for public safety and for the rehabilitation and well-being of the prisoners.
Comments? L'honorable député de Beauport-Limoilou.
Member for Beauport.